Welcome to our YouTube video series on contract law. My name is Christopher Neufeld of Neufeld Legal, and in this particular video, we will be discussing the two primary components of concluding a contract, that of offer and acceptance. For purposes of creating a legally binding contract, an agreement must necessarily be made in the form, or what is equivalent to the form, of an offer of the matter or terms of the agreement on the one side, and an assent to or acceptance of those terms on the other side, as seen in the following examples. At a sale by auction, each bidding is an offer of a price for the article put up for sale, and these biddings may be successively made until one is accepted by the fall of the hammer when the agreement is completed. The sending of an offer for goods to a merchant or tradesperson is in effect an offer to purchase, and the sending of those goods is an acceptance of the offer and creates a contract of sale. The publication of an advertisement offering a reward for information respecting a loss or a crime is an offer to any person who is able to give the information asked, and the acceptance of it by giving such information creates a valid contract. A correspondence between two parties by letter may contain an agreement which will produce a contract as binding as if drawn up in articles and signed by the parties as such. But there must be found in the correspondence a proposal of terms met by such final acceptance as import a consent of both parties. The same construction must be put upon a letter or a series of letters that would be applied to the case of a formal instrument, the only difference between them being that a letter or a correspondence is generally more loose and inaccurate in respect of terms and creates greater difficulty in arriving at a precise conclusion. An offer unaccepted, or what amounts to the same thing, of which the acceptance is not communicated to the party making it, does not constitute an agreement so as to conclude a contract. The defendant sent to the plaintiff a letter offering to guarantee to the plaintiff the debt of a third party, and the plaintiff, that he gave credit to the third party on the face of such guarantee, did not communicate his acceptance of it to the defendant. It was held there was no contract, and that the plaintiff cannot maintain an action upon the letter. A person wrote a letter to another offering to purchase of him a horse, and stating that if he received no answer, he should assume that his offer was accepted, to which letter no answer was returned. It was held that the letter unanswered did not constitute an agreement, and the person in making an offer has no right to put upon another the burden of notifying his refusal by letter or otherwise. The contract arising from an agreement dates from the acceptance and not from the offer of the terms. Accordingly, under a contract of sale, passing the property in goods sold, the title of the purchaser dates not from his offer to purchase, but from the acceptance of the offer, and therefore he cannot sue for conversion of the goods committed before the acceptance, though after the offer. Now we see these two critical components over and over again that are required to form a legally binding contract, that of offer and acceptance, and it's acceptance of the offer that is originally proposed. Thank you.